Norwig. I am the Executive Director for PSYPACT, and I'd like to welcome everyone to this webinar session. This is the first one of these that we have done. And actually, we need to thank Sandra Panico from North Carolina for suggesting this and getting us all together. What we were hoping to do was to provide some information regarding how disciplinary actions would work under PSYPACT. So we're going to have a little bit of introductory slides, and then I'm going to turn it over to Doug Wolfberg, who is the legal counsel for PSYPACT Commission, and he's going to run us through that material. I would love to take time to get an idea of who all is here, but I'm afraid that we may not have enough time if we do that. So if you could provide your name and your position and what jurisdiction in the chat box, that would be great. And we're also hoping to have enough time at the end for some questions and answers and fill in that kind of time as well. And there will be a survey that will be sent out to you after this session so we can get some feedback, because like I said, this is the first time we've done this. So we would like to continue to do these and address different issues that come up. And so the surveys will help us get some feedback as to how we can improve these going forward. So if we're all ready, we'll get started with the presentation. Next slide, Doug. So I think everybody knows what PSYPACT is the Psychology Interjurisdictional Compact. It is an interstate compact, and it is designed to regulate the telepsychology part of psychology practice, as well as temporary in-person face-to-face practice. And that allows you to go into another jurisdiction for up to 30 days to do a session for face-to-face. That is not 30 consecutive days, and it is 30 days in any PSYPACT jurisdiction. And it also focuses only on psychology and psychologists. There are some other compacts that address other healthcare professions, such as counseling and social work. So PSYPACT only deals with psychology. Next slide, please. So we've been working on this for a long time. ASPPB heard from its member jurisdictions back earlier than 2011 about a mechanism in order to regulate telepsychology. So they created a telepsychology task force that worked on this issue from 2011 to 2015. And they finally created and had approved the language in 2015, but it was done in February of 2015. So it was a little late for the legislative session for that year. So the first state to enact PSYPACT was Arizona in 2016. Georgia enacted the PSYPACT language in July of 2019. And why that was important was that was the 7th state. In order to get PSYPACT up and going, we had to have 7 states enact the legislation. And so at that time, when they enacted it in 2019, in July of 2019, we had the first PSYPACT meeting, and then we issued our first authorization in July of 2020. Next slide, please. We've had a good bit of growth since 2019. So we are now up to 42 jurisdictions that have enacted the legislation, and 40 of those are effective. So that is a misprint in my slide. Sorry about that. There are 40 that are enacted. South Dakota and Vermont both will come on July 1st, 2024. And Mississippi, we welcome them to the compact as of today. They became effective this morning. Next slide, please. So how many authorization holders do we have? As of Friday, we have 12,874 authorization to practice interjurisdictional telepsychology, or APIT holders, and we have 746 temporary authorization to practice holders. Next slide. I think everybody knows how this works. States enact the PSYPACT. The PSYPACT Commission was established, like I said, when we had 7 jurisdictions. The psychologists that want to practice under PSYPACT, they apply for their APIT, or their authority to practice interjurisdictional telepsychology. That allows them to practice telepsychology into a receiving state. If they want to practice the temporary component under PSYPACT, they apply for a temporary authorization to practice, or the TAP, to conduct temporary in-person face-to-face practice in a distant state. Next slide. So one of the things that I think has been confusing, and just want to make sure that everyone understands, like I said, when I started talking about the history, ASPPB was responsible for creating PSYPACT. They did that back in 2015. However, when the commission was formed and created in 2019, it became a freestanding entity. It is no longer part of ASPPB. It is its own entity. So when you're looking at this slide, the things that ASPPB is responsible for are the e-passport and the interjurisdictional practice certificate. That includes applications and renewals. And those are one of the requirements for getting the authorizations that are issued by the commission. In order to practice under PSYPACT, you have to have the APIT and TAP, which are issued by the PSYPACT Commission. Next slide. And I am going to turn this over to Doug. Thank you.
Okay, thank you, Janet. Good afternoon, everyone. Thanks for joining, and thanks for the opportunity to share this information. My name is Doug Wolfberg. I am legal counsel to the PSYPACT Commission, and we are also affiliated with the Council of State Governments, which helps, particularly the National Center for Interstate Compacts, which has helped to develop and implement and provide ongoing assistance to interstate compacts in multiple areas across occupational and professional licensure. And in addition to representing PSYPACT, I represent 3 other current interstate compact commissions in the area of healthcare licensure, and a couple of more that are in the process of coming online. So I appreciate the opportunity to be with you. I am a healthcare lawyer by training, and have done a lot of professional licensure and disciplinary work with state boards and on the defense side as well. So that's just a little bit about my background. So some of these, and I know that the primary focus here is navigating disciplinary issues. We're going to get into that. We're going to get into some scenarios, but we wanted to also provide some background with regard to the model compact and sort of some of the key operating provisions of the statute, because they do inform what we will talk about on some of the disciplinary stuff too. So some of the basics, and you know, some of you, this is absolutely review. Some of you are very well familiar with this. Some we have who are newer and may have responsibility for multiple boards through your agencies. So we wanted to take a few minutes to just do some of this background and introductory stuff. So the Model Compact statute allows the commission delegate to be the executive director or similar board executive of the state psychology board, or the entity that oversees psychology licensing, a current member of that board, or a more sort of catch-all authority for any designee who is empowered with appropriate delegate authority to act on behalf of that compact state. We do note that the bylaws all do, and the compact leave up to the state the designation of their delegate, with the caveat that the state needs to consider potential conflicts of interest in appointing their delegate to the commission. So that is a responsibility that's placed on the state. And then, of course, there are commission conflict policies and also things like that are under development as well. So it's a bit of a mutual process by which the state and the commission together ensure that there are delegates who can act on behalf of the state and that are free from conflicts which could materially limit their ability to serve as a delegate. Now, one thing that's come up a lot lately, which is a question that we always like to answer when we talk about interstate compacts, is what exactly is it? Because it seems to occupy this region between the familiar and the unfamiliar. It's not exactly state government. It's not a nonprofit organization. So what is it? Well, it's what we call a body politic, and it is an instrumentality of the state governments, the states that enact the compact and become members of the commission. The PSYPACT Commission, the Interstate Compact Commission, acts as an instrumentality of those state governments. And it is an entity vested with rulemaking authority So it's really, in essence, a multi-state governmental rulemaking body. It is not, for example, a nonprofit organization or a tax-exempt 501c3 organization, nor is it a professional association. And that's important because in some cases, there have been sort of misapprehensions about the nature of the Compact Commission and what can and can't be reported, for example. So it's important that we classify it appropriately as what it is, which is a state instrumentality. Meetings of the commission are open in public, except if a meeting or a portion of it is closed for specified reasons in the compact. The model compact does provide provisions for limited qualified immunity for commission staff and representatives who act in the course of their commission duties. It's also important to note that there's nothing in the compact that would provide immunity or at all weigh in on the venue in a professional liability action against an individual psychologist. And that's been another source of misapprehension in some states, particularly when state trial lawyers associations and others review the compact legislation. They seem to have those concerns when they see the words immunity and venue. But nothing in the model compact would at all declare any preference for a venue or confer any level of immunity on a practitioner. So there's no change of the status quo in terms of malpractice or professional liability actions. Now, one other thing that PSYPACT has sort of led the way on a bit is having structured rules in place to determine that when states enact the compact, to ensure that there's conformity. I mean, a compact is a statute, but it's also an agreement between states to conduct business on the subject of the compact, right? Because you all can regulate things outside the compact in ways that the state sees fit. But when states enact a compact, they all agree to do certain things in a certain way and then receive the benefit of knowing that the other states are going to do it that way as well on those compact matters. So for that reason, compacts do need to be enacted substantially in the form that they have been enacted by all the other participating states. So there is a process that PSYPACT has adopted through rules that review the enactments of each state. Because if a state says, knocks on the door and says, well, we've passed PSYPACT and we're ready to join, but all that they've passed is a bill that has the name and every other, all the other provisions are different. They really haven't enacted PSYPACT, right? So to protect all of the states that are members and ensure consistency in how the interstate compact is administered, the states have to enact the compact in substantially that same form. I say substantially because I'm a lawyer. We get paid to use words that have wiggle room, but the idea is that we've seen states that have had codification instructions, for example, or that renumber provisions to fit within their code formats and that sort of thing. And then there could be other changes that are absolutely non-substantive, for example, that specify who in that state, for example, would be administering aspects of the compact or whatever the case may be. So, but without getting into specifics, the PSYPACT regulations do specify examples of the kinds of things that would be seen as material deviations from the compact. And then there's a process for the commission to review new enactments just to ensure that there's that consistency and all states are on the same sheet of music. Okay, now one definition from the model compact that does directly relate to some of the disciplinary scenarios we're going to talk about is the definition of a home state. And let me say that if you are reading the compact and parts of it leave you scratching your heads, just be aware that some of these leave all of us scratching our heads in some cases, trying to make sure that we are faithful to what statutory language and the intent were. And, there has been a process that we, and I think others prior to us, have issued legal opinions to help the commission clarify maybe some of the language where it's not 100% clear in its meaning or intent. in any event, the definition of a home state is a compact state. So it would be a state that enacted the compact where a psychologist is licensed to practice. So right off the bat, we see that psychologists can, of course, be licensed in more than one state and therefore have more than one home state. A psychologist can also, of course, hold licenses in non-compact states, states that did not enact the compact, but the PSYPACT privilege cannot apply in non-compact states, and licenses issued by non-compact states cannot qualify that person to have a PSYPACT privilege to go practice in other states. So non-compact states cannot import practitioners from other states under the compact, nor can they export practitioners to other states under the compact. If your state has reciprocity, for example, with bordering states or something along those lines, that's a matter not governed by the compact. And that, of course, would be subject to whatever your existing state law says. Commission rules go on to specify a little bit more detail about the issue of home state. So if a psychologist is practicing interjurisdictional telepsychology, and remember Janet mentioned that there's a TAP, which is a temporary authorization to practice, which means temporary face-to-face practice within a distant state, or there is the practice of telepsychology through an APIT, an authorization to practice interjurisdictional telepsychology. And one of the questions that came up early on and was reflected in the drafting of the compact is if there is an act of unprofessional conduct that occurs in the performance of telepsychology, the drafters wanted to obtain some clarity in whose state would have jurisdiction. Now, we're going to do some scenarios. You're going to see it could be multi-state jurisdiction, but there is at least an effort to achieve some clarity on some of these things through the compact. So if a psychologist is practicing telepsychology, the rules of the commission say that that psychologist must identify the home state for that purpose. Now that can be changed. There is a process for changing that based on the practice of the psychologist, but that psychologist is responsible to designate and then update when necessary a home state designation so that it's clear jurisdictionally among other reasons. And remember, a home state does need to be a compact state in which the practitioner is licensed. So where there's more than one home state, the compact does require the psychologist to make a designation for purposes of practicing telepsychology. And then the psychologist would have to originate those telepsychology interactions from that designated home state, unless and until they changed it to another home state. And that's, I previewed the next slide. So the rules also say, and the model statute also says that the psychologist initiates patient contact in a home state via telecommunications technologies with a client or patient in a receiving state. So a couple of things here. Remember, the statute says in a home state is where it originates. The rules go on to say in the designated home state, so it gets a little bit more specific. And then the other thing, just to be clear, is that the rules and the model statute itself do differentiate how we refer to a state depending on whether it's in-person practice or telepsychology. If it's telepsychology, we call the state where the patient is located a receiving state. And if it is in-person practice under the privilege, it is called a distant state. So in some of these slides, as you're going to see here, we are generically referring to that other state where the patient is located as a remote state. But just be aware that there are terms of precision in the compact itself. If it's telepsychology, it's considered a receiving state. And if it's in person, it's considered a distant state. Okay. Some additional detail on that home state definition. As I mentioned, if the psychologist is licensed in more than one compact state and is practicing telepsychology, the home state is the state where the psychologist is physically present where when the services are delivered. So if you read the compact and the rules together, it is pretty clear that the services need to be originated in a compact state, that is a state where the psychologist is licensed and where they have designated that home state for the purposes of practicing telepsychology. So there's kind of a hierarchy of 3 requirements to be able to initiate telepsychology into a receiving state. Nah, I was going to say, I want to confuse the issue of telepsychology. I'm going to leave it right there. If there are questions, happy to answer them. Some other detail, if the psychologist is practicing in a distant state under the temporary authorization to practice and is licensed in more than one state, the compact says that the home state is any compact state where the psychologist is licensed. So there's a little bit broader of a definition if it's in-person practice. It is more precise if there is telepsychology practice occurring under the compact. The scope of practice for a psychologist, whether practicing in a distant state under a temporary authorization to practice in person or practicing telepsychology in a receiving state, the scope of practice is always that of the state where the patient is located, i.e. the distant state or the receiving state. So, you know, that's one issue that becomes central in disciplinary cases, and we'll talk about that in a few minutes when we do some disciplinary scenarios. But scope of practice always follows the remote state. So psychologists who are crossing jurisdictional boundaries do need to be aware of that. And that is not unique to PSYPACT, by the way. Those of you that are involved with other boards and other compacts know that that is the predominant model in, I think, every healthcare occupational licensure compact except one that I know of. But in any event, that is the predominant model. Scope of practice, by the way, is defined in commission rules to be the procedures, actions, and processes that a psychologist is permitted to undertake in that state and the circumstances where they're allowed to undertake them. And scope of practice, I think, as we all know, can really come from a variety of sources, right? It can be prescribed by statute, it can come from rules and regulations promulgated by a state board. Case law can hand down decisions on what is or isn't appropriate, and other processes that might be available to the state licensing authority. If it has the authority to issue a bulletin or a protocol, for example, if it has that statutory authority. So scope of practice can come from many sources. I mean, as we all know from case law like Dobbs, statutes that were enacted after Dobbs, right? So we know that it can be statutory, it could be case law, it can be regulatory. So we get asked a lot, well, how do I know what the scope practice is? Isn't the commission going to put out a thing that says what it is in each state? That's such a broad topic and such a moving target. It is a professional responsibility of any practitioner in any discipline to really know what the scope of practice is in the state they intend to practice in. Some additional requirements for temporary in-person practice under a TAP. A psychologist operating under a TAP is also subject, and this is over the years been another question that's come up under the model compact. Not only are you subject to the scope of practice when you go into the other state, which is their clinical rules and guidelines, but the statute says that the psychologist is also subject to state laws to protect the health and safety of its citizens in the distant state. Now, this same language does not also appear in the section dealing with telepsychology. So the implication of this language is that these are laws that deal with your physical presence in another state. I mean, the simplest example would be you can't go flying through a school zone when the sign's reading, 15 miles an hour, right? Laws that deal with your physical presence in that state that wouldn't also be applicable when you're practicing telepsychology. So there's an additional duty imposed on psychologists when they go physically into another state to be aware of laws that deal with the health and safety of citizens in that state. Now, because the statute used that term but did not define it, nor did it provide examples, last year, the year before, I can't remember the timeline, Janet, but we proposed, the commission proposed and then finally adopted rulemaking to try to clarify what that phrase, additional laws to protect the health and safety of citizens in the distant state, what that means. Examples that came up that were then put into the rules of the commission include, for example, laws on abuse reporting, laws dealing with informed consent and the manner in which it must be obtained, laws that require a psychologist to make disclosures of risk, so Tarasoff type laws, laws prohibiting an individual from engaging in conduct that causes or may reasonably cause another to suffer physical or psychological harm, laws establishing standards or processes for involuntary commitment, for example, or involuntary treatment. So again, this was merely an attempt to provide examples of what the prior slide meant, right? That phrase, state laws to protect the health and safety of citizens in that distant state. This is not an exclusive or an exhaustive list, but it was an attempt by the commission to promulgate rules to provide some guidance to states on just what that undefined term in the statute meant. Okay, deep breath. I'll take a sip of water here. And we will move on to the disciplinary process. And I think Janet mentioned it, but I also do very much want to thank Sandra Panico from North Carolina as well for serving on our little steering committee to really help give voice to the kinds of questions that I think many of you have and to provide some practical scenarios. So I just want to provide that acknowledgement as well. So let's talk about PSYPACT and the disciplinary process. This is an eye chart to see how well you all can read and how well your eyes are working. So this is also, I think, in your handout materials. Is that right, Janet? Yes. So I'm not going to go over that. We're going to go through some of the more specific things from the disciplinary standpoint. Okay, first and foremost, and this is really important. Well, I hate it when somebody says that because it implies all the other stuff I've been saying isn't. This is really important, though. But this is important, okay? And that is that a home state, that is a state that issues a license to a psychologist, always, always, always has the authority to impose adverse actions against a license that state issues, okay? So that's a state that issues a license, controls discipline action against that license, consistent with that state's laws of due process and substantive law that determine what is or is not an act of unprofessional conduct. State issues a license, a state can enforce professional standards regarding that licensee. All right, so that much is clear in the compact. Now, what happens when somebody goes into another state? And that's when interjurisdictional discipline gets tricky. All right, and we'll try to clarify this as best as we can. So when a person goes into another state, a remote state, to practice in person, right? Remember, that's the temporary authorization to practice in a distant state. That distant state can take adverse action against practice that occurs in their state. And if you think about it, that sentence makes inherent sense, right? Because the distant state, when a practitioner is exported into that state under a compact privilege, they do not hold a license from that distant state. They're practicing under the privilege. So the most that distant state can do is say, under our laws and our rules of due process, you did X, you therefore no longer qualify to exercise that privilege in our state. You cannot discipline or revoke that person's license because you didn't issue it, right? But you can restrict their privilege to practice in that state because they're in your state, right? So that's a fairly, I think, straightforward place to start. Similarly, if a psychologist is practicing telepsychology in your state, they're physically in another state, but they're providing telepsychology to a person who is physically in your state, because that's where the patient is located in the receiving state. That receiving state can also take action against that APIT, that authorization to practice interjurisdictional telepsychology, in that state. All right. So very clearly, when a psychologist is practicing in or into your state, either in person or through telepsychology, that remote state has authority to take adverse action against the privilege, the PSYPACT privilege, that allowed that psychologist to practice in that remote state. Now, the effect of that adverse action is the second thing that comes up, all right? And remember, all states, whether you're taking action against a privilege, an APIT or a TAP, or if you're a home state taking action against a license, you are always bound and guided by your disciplinary rules, your rules of due process, notice, opportunity to be heard, right? All of those things that would normally apply in any disciplinary proceeding would apply equally under the laws of your state. Now, if a home state takes adverse action against a license, right? So this is the state that issues a license. There can be more than one, of course, but if any home state, a compact member state, takes adverse action against a license issued by that state, all PSYPACT privileges, both TAPs and APITs, are terminated. And this would be the case if the psychologist also holds a license in another state or even another compact state. So if state A and state B are both compact states and a psychologist holds a license in both, revocation, for example, of state A's license by that state board results in loss of the PSYPACT privilege. The psychologist cannot say, good thing I've got a spare license, right? Because it's very clear that the action of revocation or adverse action by a home state against the licensee results in termination of PSYPACT privileges. Now, who investigates and who acts? Here's where the clear starts to get a tad bit fuzzy, but we'll do our best. All right. Now, if the psychologist is practicing telepsychology, remember, earlier on, we were talking about the requirement that a psychologist, if holding a license in more than one compact state, must designate the state from which they will originate telepsychology as the home state, all right? So that designated home state for purposes of telepsychology, alleged acts of unprofessional conduct that occur in the provision of telepsychology, that designated home state, as designated by the psychologist, shall investigate alleged inappropriate conduct in the receiving state, okay? Now remember, the receiving state always has the ability to limit the privilege that the psychologist exercises in their state, but that also necessitates the designated home state to investigate. It does not mandate or compel action or adverse action. That home state, of course, has the prosecutorial discretion and the investigative discretion to review and determine if no charges are warranted or no, whatever you call it in your state, order to show cause or administrative complaint or whatever it might be. So it's not a compulsory discipline. It is a compulsory, at least, investigation. All right. So active unprofessional conduct occurs in a receiving state practicing telepsychology. The designated home state shall investigate that alleged inappropriate conduct. The home state then has to investigate and take appropriate action as it would if such conduct had occurred within the home state, and the home state's law controls in determining any adverse action. So you're now being investigated and judged, so to speak, by the home state. That home state's laws on due process, notice, opportunity to respond, requesting a hearing, all of the things that happen under due process would control in that home state that was designated by the psychologist under an APIT. Now, if the conduct occurred under in-person practice, under a TAP, temporary authorization to practice, the distant state in which the psychologist is physically practicing shall investigate alleged inappropriate conduct occurring in that distant state, and the distant state must investigate and take appropriate action, and here's where it gets a little tricky, as it would if such conduct had occurred within the home state. However, the distant state's laws shall control in determining any adverse action. I'll give everybody a second for their heads to stop spinning. So there does seem to be some, on the surface, contradictory language. As questions pop up, I will ask folks to sort of hold those. We're going to go through a couple of sort of scenarios, and then, of course, whatever questions remain after that, we'll tackle them as best we can. Okay. Now, states also have the option, as most of you already do, of alternative program participation, whatever your state might call it. This is essentially a disposition in lieu of disciplinary action, most often used for substance abuse, health-related issues, addiction, etc. So a state always has the option so any state, home state, distant state, receiving state, of adjudicating or disposing of a matter through alternative program participation. The only express condition on alternative program disposition is that a psychologist cannot practice under a privilege in any compact state during the term of that alternative program. So if it's a one-year supervised monitoring drug treatment program, for example, whatever that might be with periodic drug testing or whatever the case is, as long as those restrictions or that alternative program participation consent decree or whatever it is in your state is in effect, the psychologist's PSYPACT privileges are limited. Now, of course, if a home state puts an alternative program disposition on a disciplinary matter and allows the person to practice in that state in which they hold a license, that is perfectly permissible, but that psychologist cannot be exported into other states under the PSYPACT privilege during the term of the alternative program participation. Okay, so the statute invests some additional authorities into state boards. For example, you all already have the ability to issue subpoenas, but for interjurisdictional investigations and adverse actions, there is also an express authority to issue subpoenas. Those subpoenas issued in compact states are enforceable in other compact states, subject to the state's rules of practice and procedure. So, for example, if you are a state issuing a subpoena for alleged inappropriate conduct or unprofessional conduct, you serve that on the practitioner who is physically in another state. How a subpoena has to be served, whether it requires personal service, whether it can be served by mail, whether it can be served electronically, that state's laws would control, which is basic legal principle. You have to adhere to the laws of the state in which the person is located under principles of personal jurisdiction to make sure that service of that subpoena is appropriate. There's also provision that the issuing state pays witness fees and travel expenses as required by law, et cetera, if you're going to compel a witness to testify or appear, and that state's law says, they get the grand sum of $9.12 a day or whatever those very generous witness fees are, that would have to be paid as well. States are also vested with the ability to issue cease and desist orders or to seek injunctive relief to revoke a TAP or an APIT. All right, let's get into the fun now. Let's do some scenarios. All right, here is scenario one. This is a licensee from another state committing an act of unprofessional conduct in your state. So you are a remote state. A PSYPACT practitioner licensed in another state has been exported into your state under a PSYPACT privilege. Okay, so here's where we're sort of generically referring to those states as remote states. I'll be more specific when we need to be, right? But a remote state, a distant state for TAP or a receiving state for an APIT, has the authority to investigate actions taken in their state, right? We already sort of talked about that. The remote state can take adverse action against that TAP or that APIT. So a remote state always has the ability to prevent a PSYPACT practitioner from operating in their state, either through telepsychology or in person, if that remote state believes that that psychologist has committed an act of unprofessional conduct. So states always have the right to essentially ensure the health and welfare of their citizens, right? Now, the remote state would apply both the procedural rules and the scope of practice of its state in making that adverse action determination under a TAP or an APIT. So if a psychologist, for example, failed to discharge a duty to warn that was present in your state, or violated post-obs statutory provisions, or whatever the case may be, that remote state would not only use its due process rules on service of a complaint, time to respond, requesting hearings, all that fun stuff, but also the scope of practice would apply in the state where the patient was located and the services were provided. Now, that remote state would then have to report what's called significant investigatory information, as well as any adverse action that ultimately results from that investigation, to the commission via the database, right? Because we already saw home states then have certain responsibilities. They only know about that if reports are made in the manner that the model compact provides. So to continue on with scenario one, if the action in the remote state was related to telepsychology under an APIT, right? So the distant state has taken action or launched an investigation. They notify the commission through the database. Remember, that now triggers a duty on the part of the home state to investigate. Remember, the home state that is designated by the psychologist for purposes of interjurisdictional psychology is the one who then has to pick up that ball. The home state shall then take any appropriate action as if the conduct had occurred in its state, okay? Now, remember, and here's where that seemingly conflicting language starts to get a little clearer, I hope. That's my opinion. If you don't think it's clear, you get to ask questions. But so now, remember, the remote state has taken action. Now it goes back to the home state because that triggers the duty on the part of the state that issued the license, all right? Now that state is deciding whether adverse action against the license is warranted. So it applies its own procedural and scope of practice rules. So if the distant state, or I should say the receiving state, for example, disciplined and terminated the APIT because the person violated, let's say, a Dobbs limitation, but the home state that issued the person's license has no limitation like that, there's no basis to discipline that person's license because they did not violate a law of the home state that issued the license. That is the reason in this scenario, the home state's both procedural and substantive scope of practice law applies, okay? So that, I think, makes a little bit more sense when you apply it on a specific scenario. If the action was related to practice under a TAP, an in-person temporary authorization to practice, then the remote state applies its own procedural rules and scope of practice if determining if adverse action is warranted. Remember, in an in-person setting, the distant state is given that authority or that responsibility to investigate and take adverse action. So now, for instance, if to use the Dobbs scenario, if the practitioner came into your state physically, violated, say, a Dobbs statutory restriction, your state law would absolutely apply because that psychologist had a duty to respect your state law when they were physically in it, okay? So that's why there's a bit of a distinction between telepsychology and in-person practice. Okay, another deep breath, another swig of water. And we'll do scenario two. Scenario 2 is if a licensee in your state, so a person who holds a license that your state issued, commits an alleged act of unprofessional conduct in some other state, another compact state, under a TAP or an APIT, okay? Now, if this conduct occurred in a remote state under an APIT, telepsychology, remember, if you are that psychologist's designated home state, you must investigate. Doesn't compel you to take adverse action, but it does require a designated home state investigation. If the conduct occurred in a remote state under a temporary authorization to practice, physical presence of that psychologist in that other state, the remote state must investigate and may take adverse action. Period, end of sentence. Now, remember, home states always have authority over a license that they issued. A home state, of course, may take adverse action based on the adverse action taken in the remote state. Say, for instance, that both states, to stay on the Dobbs example, are aligned on their Dobbs statutory obligations. The psychologist violates that in the remote state. The home state could use that as a basis for discipline as well, if that is permissible under the home state's laws. So that's the reason there's a distinction here between, again, the in-person practice versus the telepsychology practice. Okay, so those two scenarios, as clear as they could possibly be, I am 100% confident. I'm going to turn it back to Janet, who's going to wrap up some of the other remaining slides, and then we'll have some time for Q&A. So Janet?
So I just wanted to highlight some of the rules of interest that were addressed in today's presentation. So rule number 7, dealing with adverse actions, kind of gives you some extra information regarding investigations as well as the reporting requirements. Rule 8 gives you some information regarding subpoenas. And then Rule 9 has a lot more information. We do not utilize the coordinated information system as far as getting all of your data of your licensees, but there are some components that are required. We utilize the ASPPB PSYPACT system to gather our information. So we do talk about in Rule 9.5 utilizing that system. Rule 9.6 talks about the frequency in which you must report adverse actions. And 9.7 and 9.8 also cover the frequency for using reporting significant investigatory information and reporting non-confidential information. The board admins have access to the PSYPACT section under PSYPRO, and in there is a component that deals with the disciplinary data system. So that is where when you log in and go to report a disciplinary action, there is a series of questions that will ask you, does the discipline fall under one of these? Is it an adverse action, reporting significant investigatory information, or a non-confidential information related to an alternative program? And based on how you answer that, it'll tree you toward the appropriate place to enter that information. Next slide, please. And this, I just wanted to highlight the policies. The policies are on the website at this link, and it is the entire book of policies, but 3.1, 2, and 3 are the 3 policies that deal with more information regarding discipline. It also talks about, we've talked about what you guys do, but it also talks about what we do as far as deleting or once an authorization is terminated. Next slide. So all of our information can be found on the PSYPACT.org website. Under, like I said, under the commission tab, you'll find the information regarding the original statute law, our bylaws, the rules, the policies, and any legal opinions that have been issued are all found under that section. Also, you can find information about our meetings. As Doug said, they're all open to the public. We certainly would encourage you to attend. We would appreciate it, as well as kind of keeping up with where we stand as far as jurisdictions. And then we also have information just for the authorization holders regarding applying and things like that. Next slide, please. And then this is information regarding PSYPACT staff. Ashley and Gina can assist, as well as I, for any questions that you may have. And that's all I have for our slides.
I should note that if my contact information is not on there, but you can, any questions for me, you can certainly route those through Janet, and she's very good at pinging me when needed. So,
He cannot hide from me. He may try, but he can't, so.
so Janet, I don't know if there's questions in the chat. People can certainly share them there, or people can unmute as far as I'm concerned and just ask questions. Do you want to moderate those?
Sure, I do not see any chat questions, so if people want to raise their hands and ask questions, I think that'd be great. All right, John, you want to go first? You're the first hand I see.
For purposes of the designation of home state, how is that maintained? How is that discoverable? Is that for all of their patient relationships, or is that per relationship, in which case would that be disclosed in the disclosure with the client? How is that done?
So the home state is actually identified by the psychologist during their application process. So when they're getting their APIT authorization, there is a section where they can identify their home state. And that is verified that they do have a current active license without any restrictions on that during the application process. If they change their home state, they are able to do that through the PSYPACT system as well. They would log back into their record and go back to their APIT application and designate a new home state. That information is available to the PSYPACT board staff. I mean, at the jurisdictional level, they have access to the PsyPro system as well as the PSYPACT directory that would show them any psychologists that have designated their home as their home state. They can do a search by that, as well as our verifypsypact.org site has a directory, a public-facing directory that allows people to look up practitioners, and that also shows the states in which they are licensed.
Thank you.
Mhm. So I have one question in the chat box. Under TAP, the remote state is taking action against another state's license. Is that correct?
No, the remote state, the most a remote state can do is limit or revoke a privilege to practice in that state. Only a home state that issues a license can take disciplinary action against a license. So remote states can limit the ability of a person to practice under a privilege in their state, but only a state that issues a license can take that action. If you take an action as a remote state, you report it so that a home state can review it and determine if action is warranted against the license. But the remote state cannot take action against a home state license.
I have no more questions in the chat box and I see no more hands. Any other questions? Oh, Heidi?
Yeah, I'm wondering if there could be some legal implications if a remote state and a home state are conducting essentially the same investigation, the same set of allegations. Is there any concern with the remote state taking action ahead of the home state, or should the remote state, in other words, should the remote state sort of, pause its investigation or gather facts and then sort of wait to see what the home state determines? Or do you see that either jurisdiction can sort of move ahead in their process and arrive at an adjudication ahead of the other? So I think about this from a sequencing perspective. Are there any concerns or even considerations to make along the way?
Well, that's a fantastic question. And the statute, neither the statute nor the rules speak to sequencing. I would say that there is de facto some sequencing, because if, let's say that an active alleged unprofessional conduct did occur in a remote state, a home state may well not know about that until it's reported by the remote state through the database that we have significant investigative information because somebody came to us and we launched this investigation. So I think, practically speaking, it is more likely that the remote state would have knowledge of that unprofessional conduct or alleged unprofessional conduct before the home state would. As far, and that's just a practical guess on my part by the way that the database reporting would work. But I think that from a practical standpoint, in terms of deferring prosecution, for example, I don't have a strong opinion about that. I think each state has the right to act to protect its own citizens. And if state B is dragging its feet and state A is dissatisfied about that and thinks there's an urgent reason to take action, they have every right to do that. That said, I think another upshot of your question, Heidi, is that the states are absolutely free to coordinate, just so that they're not trying to overlap on the dates that they need the witnesses, or, that they need the respondent or something like that, so that there's some coordination to ensure availability of witnesses, et cetera. Other than that, I think we often hear deference of an administrative matter if there's a criminal matter, right? So we kind of tend to do that, right? We don't want to prejudice a criminal case, so many administrative bodies let the criminal case proceed first. Where two states both have an option of administrative actions, one against a privileged practice and one against a license, I think the states are free to coordinate. There might be very good reasons to do that, but there's no statutory or rule obligation that they do that or go in any sequence. That's a fantastic question. Thank you for that.
Thank you. Yes, I guess I'm just, and I think you really articulated what was in my mind. Not to brag on my state, but we do move pretty quickly, pretty nimbly. We're able to do that in most circumstances. So it's not uncommon for us to find us, an investigation is open, concerning a psychologist licensed in 2 states. So I'm sort of extrapolating from that experience. Arizona moves quickly. And so I can see a scenario where, we took a summary suspension action, we're the remote state in this scenario in my mind. And so we basically said, you shall not practice in our jurisdiction, but just sort of reconciling, that knowledge with the fact that the psychologist in every other remote state, and certainly, of course, in their own home state, that conduct can continue to occur. That's just unsettling to me. So I guess what I'm going to come away with is to reassure myself that we can take the action that we find necessary to protect the public in Arizona as swiftly as we can do it, and ensuring due process, in the course of that. But we aren't really sort of restrained from doing what we feel we need to do.
That's very well said. No state is at the mercy of any other state in timing. No remote state is obligated to wait till a home state acts, and no home state is obligated to wait till a remote state acts. There's might be good reasons to coordinate, but there's no obligation to do so, and each state can move at its own pace. I do want to mention one other thing, because your response, Heidi, sort of brought up something tangentially that Janet and Sandra and I had a robust conversation about, and that is to remember that there are scenarios outside of the compact that your state laws already permit you to act, right? And one is reciprocal discipline. So say, for example, that you have a person licensed in your state and you're a compact state, but a person also holds a license in a non-compact state and is disciplined by that state. Most state laws say that discipline imposed by any other state in which you hold a license is itself a basis for discipline in our state, right? Not necessarily getting into what the conduct was, res judicata, as we might call it in the law, but the fact of that discipline in the other state is a basis for discipline in your state, right? Those laws exist almost across the board for reciprocal discipline and have nothing to do with the compact, and give states the ability to take action where the law permits for acts that occur in non-compact states, right? If a person happens to hold a license. So we had a good, robust discussion about that too, but nothing would prevent a state from utilizing any other disciplinary authorities it has that are completely separate from the compact, and nothing requires delay in protecting the public because of a delay on the part of another state. So it's a good question. It's a great scenario.
Thank you very much, Doug. I appreciate that.
Of course.
So I do not see any other hands. Any other questions? I have one in the chat box, but it's kind of been part of my closing stuff, so I'll hold it till then. If there's any other questions about the presentation. We were not sure how long to allow for this, with this being the first time we've done this. We're going to looks like give you back some time in your day, which is always lovely on a Monday, I am sure. So if I don't see any other questions, I'm going to do a little bit of closeout, unless Doug, you have anything else you want to add? No? Okay.
Nope, thank you.
So thank you very much for attending. We are recording this, so we will be providing this recording. I am not sure exactly where yet. We are looking at whether it can go on our website or maybe starting a PSYPACT YouTube channel and putting it there, because we are hoping to start to do more of these kind of webinars and informational sessions and have those going out. What we will be providing after this is a copy of the slides, as well as a PDF of that slide, that the eye chart that Doug mentioned. We will be sending that out as well, along with a link to a survey, like I said, to tell us how we did today and what we could improve. There's a section, I think, on the survey that asks if there's anything else the commission can do. So if there are any other training materials that you would like us to have, or any other informational webinars that you think would be helpful, please include that in the survey, because we are hoping to start doing more and more of these. So we greatly appreciate you guys all attending, and I hope that you enjoy the rest of your day. Thank you.